This is the time of place set for an original hearing for Nathan Carnes, offender number 261847. Is that you, sir?
Yes, sir.
Good afternoon. Is it morning still? It's noon. Good afternoon. My name is Ray Renelso. I'm a hearing officer with the Board of Pardons and Parole. I'll be conducting your hearing today. I'll be taking testimony from you, so I'll need to place you under oath. If you could raise your right hand for me, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Okay. So it looks like you are in prison right now on one case. It's case number 231501946 for failure to register as a sex offender as a third-degree felony. Is that correct?
Yes, sir.
Okay. There's also an attached conviction for a DV assault as a Class B misdemeanor. The board does not have jurisdiction over that, but that will be considered in their decision-making process, okay?
Right.
Okay, so in that case, it looks like Hurricane PD were dispatched to a family fight. Upon arrival, they observed you and your wife yelling at one another in the street. Looks like they separated you and spoke with you. You reported that you were assaulted by your wife and admitted to pulling her hair and hitting her in the face only after she hit you first. Both you and your wife had injuries to face and arms. Your wife was observed to have a mark on her neck and nose and a cut on her hand. And she reported that she only hit you after you pulled her hair. She also admitted to biting you on the arm. And then later on, officers discovered that you were a fugitive sex offender out of California. You admitted you were on the run from a warrant, and that's why you had not complied with the sex offender registration requirements. You were taken in custody and transported to jail, and during the booking process, officers located a debit card belonging to a different individual. You could not explain how you came into possession of this card. Is this correct?
Yeah.
Okay. All right. So is there still a warrant out of California?
For
You know-
probation violation, yes.
Okay. Do you know if they intend on extraditing you back to California?
They do not extradite, no.
Okay. Okay. And that conviction in California was for sex with a minor. Is that correct?
Sir.
Okay. And you have a few convictions for failure to register as a sex offender in California as well?
Yes, sir.
Okay. All right. Okay, were you using any controlled substances at the time of the offense?
No.
Okay.
I do have a history of using them.
Right. I have that you reported you first consumed alcohol at age 12, marijuana at age 13, methamphetamine age 14, and that methamphetamine is your drug of choice, and that at one time you used daily. And then in the PSI, it stated that you last used in July of 2023, but in the board packet, you said May of 2023.
So I got sober in May, and then I relapsed over the weekend in July. But then I got back on track.
Okay. And I know that UDC doesn't have any documented gang affiliation, but you admitted to being affiliated with the Crips while in California, but you're no longer active.
Right.
Okay. How's your mental health?
It's fine.
Okay. Ever been diagnosed with any mental health issues?
No, sir.
Take any mental health medications?
No, sir.
Okay. And as far as your physical health, you stated you need your hip replaced.
Yes, sir.
Is that the reason for the wheelchair?
Yes, sir.
Okay.
I'm normally on crutches, but they gave me a wheelchair to come down the hill.
Okay. What happened with your hip?
So I broke my femur, and my bones weren't getting enough blood flow, and so they call it necrosis.
Yes.
And so my hip ended up going out after my femur had healed.
Okay. Do you take any medications for that?
They gave me some Tylenol and some anti-inflammatory.
Okay. Does it help?
No,
No.
not at all.
I didn't imagine it would be. It would be. Okay. Do they have plans for doing the surgery while you're incarcerated?
I talked to the doctor, and he wants to visit me again after my board hearing, so I know about how much time I'm looking at. Because he said if it's a short amount of time, there's a waiting list to get into, and all that, and then I need to heal. So
Right. Okay.
A certain amount of time would be better to do it out there, like if I'm getting out.
All right. Okay. And that sounds reasonable.
Right.
It looks like you're not currently in programming, but that you're on the wait list for MRT, anger management, and thinking for a change.
Yeah, I've been on the waiting list since January, so I'm not sure what's going on with that.
Okay.
But that was like the first thing I did when I got here. Just tried to get into some classes.
All right. Talk to your case manager about that. Okay.
Yeah, and I also want to. I asked him about keys to a loving relationship.
Okay.
And he said it was going to be on the tablet, but it hasn't been yet. So
okay.
Then I was going to ask him to sign me up anyway.
Okay. It looks like you have one disciplinary violation for having brew.
Yes, sir.
And you received a $70 fine.
Yes, sir.
And you wrote in the board packet that you plan on residing with your wife in Hurricane and work as a tattoo artist.
Yeah.
And then some possible construction after your hip is replaced and healed. Is that correct?
What I was doing before my leg got messed up is I was working with RV Repair Pro, and what they do is when people's RVs break down, they
okay, that's right. That's right.
But when my leg got re-injured, he told me I couldn't work because it's a liability. So once that's fixed, that's a guaranteed job.
Okay. Now, with your plan on residing with your wife, here's what I want you to be aware of. And I'm not saying the board will order this, but it is a possibility. So I want you to be aware of this and have a plan B for residents. Is sometimes, given that you also have a domestic violence conviction, the board will order domestic violence parole conditions. And one of those conditions is that you are not allowed to have contact with your wife unless it is approved by APMP and a therapist.
Okay.
Okay? I'm not saying the board will order that. I'm saying it's a possibility. Okay? So you may need to start thinking about a plan B as far as residents and getting into therapy and then getting approval from APMP and a therapist. Okay?
Okay. And we've also talked about, marital counseling. That's something that we're going to do either way.
That's good. That's good. I'm glad you have that plan. I just want you to be aware of that, okay? Right. So that you're not surprised that come release day, you plan on residing with your wife and APMP says no.
Okay.
Okay? So that's something that if the board does order it, you work with your parole officer to get that resolved, and they're going to give you the steps that you need to take to make that happen, okay?
Okay.
All right. Okay, Mr. Carnes. Is there anything else you would like the board to know?
I'm not. That was pretty much it.
I mean, this one was pretty straightforward, yeah?
Yes, sir.
Okay. All right. So we're going to talk about 2 dates here. And the first one is called a sentencing guideline date. It's often referred to as a matrix.
Okay.
For you, that is November 25th of 2024. That is a suggested release date. Now, the board is not obligated to release you on that date. They can release you prior to or after that date. Their decision for a release date will depend on any programming they feel that you need prior to release or your behavior from this day forward, okay?
Okay.
One of the things, because you do have a disciplinary violation, they may say that your parole date or release date is contingent upon no more major disciplinary violations.
Okay.
Okay, which means no more brew or anything like that in your cell.
Yes, sir.
The second date for you is called the max expiration date. As of right now, that is the latest date that the board can keep you incarcerated or on parole. For you, that is September 25th of 2028. Now, this date also depends on your behavior. If you commit a new offense or are convicted of a new offense for which you're sentenced to prison on, that can extend your expiration date.
Okay.
If you abscond from supervision, that can also extend your expiration date.
Okay.
So that date depends on your behavior as well. Do you have any questions about those two dates for me?
No, sir.
Okay. So here's what will happen going forward. I will type a report, submit it to the board this week. Takes 3 out of the 5 board members to agree to make a decision. Once that decision is made, they'll notify you in writing through inmate mail.
Okay.
If you have friends or family who want to know what the board's decision is, they can check the board's website and it'll be updated as soon as a decision is entered.
Okay.
Now, it can take the board anywhere from 2 to 4 weeks to make a decision. Sometimes it does take longer. If it takes longer, don't worry about it. The board is kind of busy and they have some pretty complicated cases that they may make a decision on those cases before they make a decision on yours, okay?
Okay.
All right. Thank you, Mr. Carnes. We'll conclude this hearing.
All right. Thank you.
Well, it took just 6 days for them to make their decision, and they decided to grant. So, 11/19/2024, less than a year from the time that he got violated, he's going to be out again. And just wait till I unpack the details that Richard found on this, because it is hypocrisy at its finest when it comes to the DA and the judge, the entire system. This guy has got a record that we'll go through that too, but I had to put it in a Google Docs. It is 6, 7, 8, 9 pages long. And they call this sending a message. You'll see it a year. It's really crazy. He was given a 5-year sentence to let him out less than a year into it. And, at these Utah hearings, we're just starting to roll them out, and it's quite interesting. I'm still getting used to it. They have different styles. They have different lengths. Maybe you saw the one that lasted about 45 minutes. They had the victim speak, and this is very different. The one that we just saw, it was a revocation hearing, but we have over 100 that we're going to be rolling out, and with the results at the end of it. So let's just jump in and look at this real prince, this cockroach. At what this record now, I thank you, Richard, for finding this. This is one of those rare articles that really get into the details, whereas one article says it all. St. George News. So he's not getting the message. Non-compliant sex offender from Hurricane is going back to jail. Written on December 21st, 2023. I should reach out to Cody and say, guess what? This non-compliant sex offender not getting the message is now getting out of jail. Let's see what he writes. He's a good author. I love what he did here. So I'm going to get into it. This is going to be probably about 6-7 minutes of reading with with this unpacking. If you don't like the unpacking, you don't need to yell at me in the comments section. Just fast forward, okay? I mean, sometimes I see some of you write in the comments section, you're whining. I hate your unpacking. But it's like, I don't talk during the hearing. What are you complaining about? Fast forward if you don't like my unpacking. All right, I got that off my chest. The fate of Hurricane Man, accused of failing to register as a sex offender and assault, was decided in large part by an extensive criminal history with dozens of cases for crimes he committed out of state during a sentencing hearing last week. Nathan appeared at 5 District Court on December 14th for sentencing on third-degree felony count of failing to register as a sex offender, misdemeanor assault, charges the defendant pleaded no contest to on October 12th. A third felony charge of unlawful acquisition of a financial card was dismissed in exchange for the defendant's plea. During the October plea hearing, Carnes signed a statement in support of the plea wherein he admitted to hitting his partner in the face during an altercation, and it was also noted that his failure to register as a sex offender was determined by law enforcement. The family fight that led to the arrest. The charges stem from September 25th arrest when Hurricane police, I guess there is a place in Utah called Hurricane. It's a pretty wild name, huh? Hurricane police officers were dispatched to a family fight in progress. After speaking with the parties, officers arrested Carnes on a simple assault charge, according to the charging documents. Officers then learned through a background check that Carnes was a registered sex offender who was non-compliant out of California, whereas the defendant also had an active warrant for his arrest on a parole violation. And this is the judge makes a statement about this, which is quite interesting. Remember how he said, "Oh no, that California doesn't want me." And it's interesting. It does seem certain states don't want to be left dealing with these. They'd rather them go to a different state. So, and we'll see that here. When questioned, the suspect told officers he was on the run for the warrant, and that is why he has not complied with sex offender registration, the officer noted in the report. Deputies found in the suspect's wallet a debit card that did not belong to Carnes, who reportedly said that he was not sure how he obtained it. "I don't know how it got in my wallet. I have no idea." He then told deputies he believed his brother had given him the card to put gas in his vehicle before he left California, and the card may have belonged to an associate of his brother. Formal charges were filed following his arrest in Carnes as he remained jailed in Washington County on a no bail hold. At least they have that no bail hold, right? But don't get excited. Utah, from what we're seeing, and this is a little shocking. I should say very shocking. And this is what I think is the beauty about seeing each state's parole hearings. I had a certain conception about Utah, and that was that they'd be tough on crime and all that stuff. But they might dish out long sentences for certain crimes, but for all the little stuff, they don't. They actually, it's very much like Connecticut, little slap on the wrist stuff, which is shocking. The case filed in okay, I know Bakersfield, California. I've been there. Anyways, the case that resulted in the sex offender registry requirements was filed in Kern County 2007 based on 4 charges, including 2 felony counts of lewd or lascivious acts with a child under 14, as well as 1 felony count of unlawful intercourse and 1 misdemeanor count of annoy-molest children. Isn't that just again the language annoy? How inappropriate that just sounds. Annoy. I get it. It's like, it's just, it actually seems redundant to the word molest, but really, are you really still going to use the word annoy? It's just something so wrong with that, in my opinion. I get it. It's legal jargon that the state uses, but the defendant was convicted of the 2 latter charges while the lewd charges were dismissed. He was sentenced for this crime. Guess what he was sentenced for in 2007, what California did after he did that to little children. He was sentenced to serve 1 year and 4 months in prison, but was released for good behavior after he served 270 days in custody. You can get more time for bouncing a check. From there, Carnes picked up 39 more cases. I wasn't kidding, right? A majority of which were for parole and sex offender registration violations, in addition to a myriad of other charges connected to narcotic possession, weapons, theft, and other crimes of which Carnes spent multiple terms in jail every year since his release in 2008. So just to add an emphasis to how insane this is, every year since 2008, he's been going back in prison, and they still now release him less than a year out. Dozens of cases are directly related to failing to register as a sex offender, including several violations listed as failure to register with 2 or more priors in the docket. The defendant's status is listed as violation on the California Sex Offender Registry and is not yet to be listed in Utah at the time of this report. The most recent case was filed October 2022 and is still open. The courts was likely that case prompted the warrants. Sending a message. I'm going to reach out to this writer. This guy's great. Okay, during the hearing on December 14th, the defendant's criminal background was the primary issue addressed by prosecutor. Now, here's the prosecutor's two-faced, double-sided hypocrisy, in my opinion. Who said, the state's position was that Karn's history of failing to register as a sex offender with many, many cases in California, in addition to the cases he picked up in Washington County, underscores the importance of a prison sentence in this case. Sobert said, while Karns has cited his narcotics use and other issues as the reasons he has consistently failed to register, the fact is he's not getting the message that failing to register is a serious offense. In fact, Solberg said, the defendant knows he is required to do so, which speaks to Karn's blatant disregard for the law after failing to comply over and over again. I know I'm making a mockery because now that we know it's all said and done, that he got out in less than 1 year, it's a joke. The whole thing's a joke. Karn's defense attorney, Michael Lastowski, countered by saying the client left California because authorities there kept sending him back to prison. Oh my God, that's priceless. This defense attorney said he absconded, he ran away because they kept sending him back to prison. You can't make it up, man. And his client wanted to get away from the bad influences in his home state. He came to Utah to start a new life. Since then, the attorney said his client's only crimes involve failure to update the sex registry, which is a serious crime, man. It's a very serious crime. His only crime. What about beating up his significant other? Okay, when Solberg mentioned the defendant's extensive criminal history in his home state, Lastowski said, I can't argue with that, and said his client did not update the sex offender registry once he moved to Utah because it would have alerted authorities in California about his whereabouts. Oh my God, this I love it. Imagine having to be the public attorney for some of these cases. Oh my gosh, poor guys. The defense attorney closed by saying his client's history showed that prison hasn't helped him and asked his client to be placed on supervision, which would allow him to get the help he needs. Solberg countered by saying that a prison sentence would not only act as a deterrent to the defendant, who the prosecutor also entered a plea on the assault charge, but would also send a message that these crimes will not be tolerated in Utah. Again, double talk, because we have been seeing this, Richard. I mean, we have the spreadsheets and it's crazy. They are like as lenient as Connecticut when it comes to how they handle parole. They have like, you see revocations, write-ups. None of it seems to make a difference. Well, you'll start seeing these hearings more often. It's just telling. It's really telling. You can understand. It's incredible. And Illinois shocked us with being the strictest. So there you go. District Judge John Walton addressed the defendant by saying, I'd like to make, this is the judge, I'd like to make you California's problem, but I just don't see a viable way to do that. Now, hey, give the judge credit for saying that, but isn't it funny? The judge is like, I don't want you here. But California's like, no. You got Utah, you can have him. We finally got him out of here. The added that the defendant's terrible criminal history and non-compliance with parole and probation has left the court with only one option to ensure that the public is protected in the sentence of Karn to serve 0 to 5 years. See the double talk? A sentence of 0 to 5, not 2 to 5, not 1 to 5, not 2 to 10, 0 to 5. And as you see, he served less than 1 year. in Utah State Prison on the felony charges with another 180 days jail and the misdemeanor, of course, running concurrent. The transport order to Utah State Prison was signed in the closed state of the hearings. He's in custody in Washington County. He's remained since his arrest September 25th. Oh, it's a woman they offered. Cody. Sorry, Cody. And I have your email. I'm sorry for. Yeah, we gotta. What do you think? Should we email her? Now that was a long unpacking, I'll share with you so you can see. You heard about all of his arrests. Let me show you. You know, Richard puts in the work by giving us all this. So let's just do a screenshot of it. So this is as of 2005. Before he had his what he did to children. So you have trespass, probation for 3 years. Then you have this act, lewd or lascivious act, under 14 years of age, unlawful. And you see, they give a slap on the wrist for this. And this is, but why not maybe have given him more than a slap on the wrist? 1 year and 4 months is what they gave him. And then he gets out and he gets immediately locked up for possession of a controlled substance. Then he gets failure to register. Then he gets violation of post-release supervision. Controlled substance, violation, failure to register, violation. I mean, at a certain point, there's Richard. At a certain point, you got to say, wait a minute. This isn't working. But it's not that it's not working because you're just when you get locked up, we've seen this and you need to get locked up for a longer period of time than just a year. Lock someone up for 10 years, 15 years. Sometimes it actually is okay because we have heard inmates say that, man, I never got a long enough stint. And then things came out of control for me. And it just goes on and on and on and on and on and on. And do you really think, it's his most recent one, possession of stolen vehicle, do you really think that he's going to go out there and do great now? I have a bridge to sell you. Anyways, we'll just go to the next hearing. But there's one thing before I let you go that I really, watching these other parole hearings, is that I appreciate Louisiana so much more now. These other states are pretty much just coasting. Louisiana takes this stuff seriously. They do. I love the way that they handle it, that they give a decision there on the spot, that the board members are these high quality, for the most part, they take it seriously. That's the point. It's not just a machine that's just pumping out, hearings. Every hearing there, they take seriously. Even if I yell at their decisions, it's just done so differently than these other states. Now, with that, I'll let you go.